Mr. Speaker, I rise today in strong support of two crucial pieces of legislation before the House. Behind every clause in these bills are real people, families shattered by violence, communities living in fear, and frontline workers desperate for stronger laws to protect us. They are declarations of our shared commitment to safety, to accountability, and to the people we are elected to serve. Let me start with Jack's Law, a law born from tragedy, driven by community and made necessary by the reality facing far too many Queenslanders. Jack Beasley was just 17 years old when his life was cut short in a senseless knife attack on the Gold Coast in 2019, and his death shook our state from all the way from the south all the way up to the north. But from that heartbreak came a powerful legacy. Legislation that empowers police to proactively search for knives and other weapons in public spaces. And the results speak for themselves. Between April 2023 and May 2025, police carried out over 115,000 wanding operations and seized more than 1,100 weapons and laid charges against over 3,000 individuals. These aren't just numbers, they're potential lives saved, violent incidents prevented, and communities made safer. But despite Jack Law delivering clear outcomes, it was burdened by Labor's red tape requiring senior officer approvals, limiting its use to predefined areas and making it difficult to respond quickly during events or emerging threats. So this bill fixes that. It removes the sunset clause to make Jack's Law permanent, and it expands its reach to more public spaces. And it also simplifies police operations by removing unnecessary approvals without compromising civil liberties. It maintains critical safeguards with body-worn cameras, randomised searches and mandatory officer training, and particularly important in far north Queensland. It gives police the ability to act before a tragedy occurs, not after. Because in far north Queensland, we know too well the cost of knife crime. In September 2021, a man was fatally stabbed in broad daylight at Cairns Central Shopping Centre. In February this year, a woman was sexually assaulted at knife point during a horrific home invasion in Menunda. And just last week, I've spoken to local principals whose schools have faced knife threats from both students and intruders. One of them was a primary school student. Another shopping centre has knives and scissors stolen nearly on a daily basis by youth and their packets found in the gardens surrounding the shopping centre. It's unacceptable, it's terrifying, and it's real. I've spoken to business owners who've been threatened and ransacked. I've spoken to parents too frightened to let their teens go out at night, not going to parties, and just to, even worried about them going to a movie or dinner with friends. And as a mother of two teenage boys, I feel that fear deeply. That fear undermines our entire community and it keeps families indoors, it drives customers away from local businesses, and it tarnishes our reputation as a vibrant, welcoming destination. Cairns Regional Council supports this law, our police support this law, and today we're strengthening it. By making Jack's Law permanent and more effective, we are saying to every Queenslander, we are serious about your safety and violence has no place here. But this isn't just about preventing crime, it's about protecting futures like Jack's, futures that deserve to unfold without fear. And while we're addressing safety, we must also fix what has been broken in our corrections system. That's why I also rise in support of the Corrective Services Parole Board Amendment Bill for 2025. This legislation closes a dangerous loophole, one that allowed a single member of the parole board to quietly overrule suspension. Recommendations made by the Queensland Corrective Service officers even when lives are at risk. So if you think about that one person, that one decision, and no requirement for review, even when the offender posed a known threat to the community, you can imagine what happens. Well, that ends today. With this bill, all urgent parole suspension decisions must be reviewed by the full board within 48 hours. So this means no more single points of failure, no more unchecked decisions that put communities in danger. I ask this House to consider a scenario that is sadly not hypothetical, a scenario we've seen versions of far too often in our regions, including places like Cairns. Imagine a repeat youth violent offender or just a violent offender someone with a history of armed robbery, assault, domestic violence, unlawful possession of weapons, or serious drug and property offences. Under the former government's weak on crime approach, this individual is released out on a court-ordered parole. Despite our hard-working community, corrections officers doing everything they can to monitor them, warning signs begin to appear. Concerning behaviour appears, dangerous messages. Queensland Corrective Services does the right thing and refers the case to the parole board, requesting suspension of the parole order. But maybe at 1 a.m, a single board member acting alone under Labor's laws is woken and makes the call to keep this individual in the community, despite the risk identified by the QCS. Then, days later, that parolee breaches curfew, breaks into a neighbour's home, assaults them, steals their car, stalks a former partner, someone they've previously abused, and she is also found in possession of a firearm. Under the current system, there is no ability for the full parole board to review or overturn that single board member's decision, and the community then pays the ultimate price. This bill fixes that. It gives the full board power to urgently review those decisions within 48 hours to stop offenders from slipping through the cracks and, most importantly, to keep our communities safe. That's how you protect the people. That's how you make a justice system work for victims, not just for offenders. Because parole is not a right, it is a privilege. And that privilege must come with accountability, oversight, and a laser focus on community safety. To be clear, this bill doesn't just lock people up and throw away the key. It ensures that dangerous decisions are reviewed, that high-risk offenders are held accountable, and that genuinely low-risk individuals can still be supported back into society, especially in those places like Cairns, Cape York and Torres Strait, where community-led, culturally respectful reintegration is essential. In Cairns and across far north Queensland, we've seen firsthand the consequences of parole decisions that prioritise paperwork over public safety. When violent offenders are released early and go on to reoffend, it's our communities, our families, our business owners, our children who bear the cost. Parole must be treated as a privilege, not an expectation. We owe it to the victims and to the people of far north Queensland to ensure that dangerous individuals are not returned to our streets prematurely. Public safety must always come first. We are closing Labor's loophole. We are restoring real-time accountability, and we are making it clear. When it comes to community safety, we will never settle for second best. Together, these two bills reflect a government that is listening, responding, and acting. We are saying to every Queenslander in Cairns, in Cape York, in Townsville, in Brisbane, that you deserve to feel safe. We are giving police and parole officers the tools they need to protect us. And we are ensuring that the lives already lost, like Jack Beasley's, were not in vain. This is what responsible, compassionate, decisive leadership looks like. So for every victim, for every family living in fear, and for every frontline worker asking for better laws, I commend these bills to the House for you.
Thank you, Member.